Hall & Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hi, and welcome to our latest Doing Business in Australia podcast episode. At Hall & Wilcox, we work with both Australian and international clients, and we support our clients with their global opportunities. We have experts within the firm who do cross-border work in many jurisdictions, including the UK, Europe, China, Southeast Asia, Japan, India, the US and Canada. My name's Mark Dunphy and I'm delighted to be the host of this episode, where we're putting the spotlight on the US. To join me in this discussion is the head of our US desk, Jackie Barrett, and special guest appearance from Ben Hamilton, who's a commercial partner specialising in competition law. I want to start, if I can, with you, Jackie. As I understand, the US remains a top source of direct foreign investment into Australia in terms of both value and in terms of volume. What sectors are we seeing American participation in particularly?
We're seeing at the moment a big growth in commercial real estate investment into the Australian market. While there's still a lot of investment in technology and mining and related industries, we've seen a big uptick in that commercial real estate space. And we think that is more to do with the current sort of trading environment. It's a little bit more challenging, changes with tariffs. Investors are looking to diversify into more stable markets. And so Australia really offers a very stable legal framework and a transparent set of regulations. It's also very attractive from a US investors' perspective because there's good interest rate cuts and the exchange rate is excellent. And so we're seeing that surge in commercial real estate probably playing out in logistics and data centres and then larger commercial buildings.
And what about in terms of, being very topical, in terms of recent strategical alliances that AUKUS, for instance, which was cemented in the Oval Office yesterday, that's got to create opportunities for US business?
Definitely, Mark. And we've already seen a lot of that from US clients coming into the Australian market, but they're looking to provide services and other support into the defence sector. But we also saw yesterday the announcement of the Joint Investment Framework, which is aimed at securing critical mineral supply chains. This is a really big venture that both the US and Australian governments are putting at least $1 billion in to start with, but with an aim to unlock up to $8.5 billion in total project investments. So this is a fantastic strategic partnership that will involve, of course, our mining industries, processing rare earth and critical minerals. And so that will have an impact on our defence, energy and semiconductor industries. So from a US investor perspective, that should create lots of opportunities for investment and coming into the market in the mining and processing sectors, lots of opportunities for collaboration and doing projects with existing Australian businesses. And so it will be really interesting to see how all of that plays out. But that was a very exciting announcement yesterday from the Oval Office.
And it's all well and good to have great opportunities for people to do business with Australia, but the Foreign Investment Review Board has often made things a little difficult. Have there been any changes in that regard?
Yes, Mark. So just for the benefit of the audience, the Foreign Investment Review Board is an Australian government body that reviews certain types of foreign investment proposals to ensure that they are not contrary to national interest. And so as part of this, FIRB will assess these applications for acquisitions of Australian businesses, land or other assets by foreign individuals or entities. And so that's obviously highly relevant to US investors coming into the market. But at the moment, we've seen increased scrutiny from FIRB on transactions that are involving acquisitions of businesses that are deemed critical to national security. So that means that acquisitions involving sensitive sectors such as telecommunications, energy, data infrastructure and defence are all more likely to trigger interest from FIRB. And that might mean in terms of practicalities for a US investor, that these changes might cause longer approval times for transactions, additional compliance obligations. And so it has to be factored in as part of your transaction. And then, of course, our special guest is going to talk all about merger clearance, and really the FIRB clearance or application process doesn't go hand in hand, but it's something that needs to be factored in with the merger clearance. And if the FIRB process is going to add time, that could have an impact on the merger clearance stuff. The other change that we're seeing from FIRB is that the Australian Taxation Office is increasingly starting to co-assess FIRB transactions. And so, again, from an investment perspective, a US investor would want to think about factoring in tax advice from the very beginning of the transaction, so that they really understand what the position is and any issues and risks that might arise in the course of the transaction that, again, might attract the attention of the ATO when FIRB analyses their application.
What about the investments that government are making into green energy solutions? Is that are there opportunities there for offshore investment?
And in fact, I think that the Australian government might be hoping that there is quite a lot of offshore investment coming into the market. So obviously they're putting a lot of money into green energy solutions and trying to really create Australia as a renewable energy hub, particularly in the sectors of solar, wind, battery storage and green hydrogen. But yeah, it does create opportunities for US firms that want to access that sort of market. There's clear policy support for this sort of investment. So you would anticipate that there's going to be easier regulatory pathways and then opportunities perhaps to joint venture or co-invest with existing Australian arrangements. So something for US firms operating in this space to keep an eye out for.
And before we involve Ben, can you talk a bit about in Australia where we're up to with AI and particularly investment in AI and opportunities for investment in AI?
Yes, Mark, there's been actually, as we know from our own business, but a lot of interest from Australian business in embracing AI solutions and technologies. This has led to an increase in different AI products entering the market. For US companies that operate in this space, particularly that have expertise in cloud services or cybersecurity or other AI platforms that might particularly operate well within services businesses or professional services businesses, there's an increase in opportunity for US businesses. We've seen it ourselves. We've seen a lot of US clients coming into the Australian market looking to launch their products and seeking out related opportunities. So I think quite an exciting time if you're operating in that space.
Thanks, Jackie. Now, Ben, the area we wanted to speak to you about was merger clearance and the new changes that are due to come into effect on the 1st of January 2026. At a high level, how significant are those changes?
Thanks, Mark. I think that it's fair to say that they're highly significant. What we're looking at from 1 January 2026 is really a fundamental shift on how merger clearance will be regulated. We are moving from what would be described perhaps as essentially a voluntary notification regime, where pre-merger you could generally seek an informal clearance from the ACCC. Look, it was voluntary and it was informal. There were other mechanisms, but generally that was the way you went about it. And the ACCC would give you an indication, that's the competition regulator, as to whether or not your merger might lessen competition in the market. What we're moving to is a world where it will be mandatory to notify the ACCC and suspend a transaction if the transaction meets certain thresholds. So what we're moving to is a regulation landscape where it's pro-disclosure. It wants merger parties to reveal details of the transaction and suspend the transaction where certain thresholds are met. And of course, what this is essentially getting at is the merger regulator will then be informed and make an assessment as to whether or not to not approve the transaction or not. Quite a significant change. And I just want to emphasize that one of the key issues here is that the Act will be breached, that is our Competition Consumer Act, will be breached if the merger meets the required notification thresholds and it is not notified and the merger proceeds. So that itself is a significant breach of the Competition Consumer Act.
And will that mean that the transaction is invalid or will the parties be subject to penalties?
It means either or. There are significant penalties for contravening this part of the Act, or will be. As you alluded to, Mark, one outcome is that the transaction is void, so it is of no effect. It's not voidable, so it's not a matter of getting a declaration to a court to say we are seeking a declaration to make it void, to make this void. It is void, and it never happened. So that's quite a significant outcome. Then, of course, penalties can apply, and the penalties in this area are highly significant and very high.
Does it apply? Is this regime going to apply to all mergers, or are the monetary thresholds that kick in?
The short answer is there are monetary thresholds. They're quite prescriptive, quite detailed, and quite finicky, if I may be so bold. So, in short, there are three different circumstances where merger parties must suspend and notify. The first one is really getting at a merger or acquisition of shares or assets which results in a large corporate group. So I won't go into the specifics, but the kind of numbers we're looking at is where the combined acquirer and target revenue, that's the Australian revenue, is over $200 million or more, and the acquired shares or assets, the revenue associated with those particular items is over $50 million. We're talking about Australian dollars. So that is in essence getting at is there are two significant parties to a merger transaction. The second threshold is where, in essence, we have a very large corporate entity which is acquiring even smaller transactions of around $10 million or more. So if the acquiring entity, their Australian revenue is over $500 million or more, and they're acquiring shares or assets in essence of $10 million, that is the second notification threshold. The third threshold is around what we call serial or creeping acquisitions. This is where merger parties need to be mindful of their historical transactions in Australia, in particular in the last 3 years. And the whole idea is you can group those past transactions, and they might be reasonably small, over 2 million per transaction, if they occur in the last 3 years, and you can basically group those figures together. So the idea is to target smaller serial creeping acquisitions. So they're the three distinct notification thresholds that require notification and suspension, and therefore ultimately approval by our competition regulator.
And what about the process that parties have got to go through to get through this?
There is a prescribed process. There are significant fees to lodge an assessment. You're looking at around 56,000 Australian dollars, and those fees will increase if further the regulator needs a further look at the transaction. But in essence, there are three phases to a notification. The first one is an initial assessment, which takes no more than 30 days, up potentially even only 15 days. And that, as I suggested, obviously with the name, that's an initial assessment. And it may well be that most mergers will be cleared within that first phase. If the regulator wants to make a more in-depth assessment, then we move into phase two. And phase two is over 90 days. And if there are issues still that the regulator is concerned with, then it will move into the final phase, which is the public benefit phase, which is where, of course, the regulator can assess whether or not there are public benefits to the merger. Now, I want to make 2 points here. One is that during the assessment, the regulator is assessing essentially whether or not the acquisition of assets or shares result in a substantial lessening of competition in the market. And that test has been around for a long time. It has been lowered a little bit and tinkered a little bit, but in essence, it's around creating or enhancing market power through acquisitions of shares or assets is what the ACCC is looking at. The second thing the point I want to make is that under the current regime, most mergers do not raise competition law concerns. And generally speaking, that is still the view of the prevailing view. So where we may well move to is a situation where more mergers, of course, have to be notified because the thresholds are being met, but it still is possible, still will be likely the case, or possibly will be the case, that most mergers will be cleared within phase one.
Given that the proposed changes are very new, are we likely to see amendments before the commencement?
I believe that the framework is there. I think there are likely to be, in fact, there is an amendment being touted right now, which will make a significant change. But in short, I believe there are unlikely to be significant amendments regarding the mechanisms, the processes, and the overall thinking. The thresholds are done by government determination, meaning they can be changed more readily than passing legislation. So it may well be the case that those thresholds, the three thresholds I mentioned, will change from time to time.
And as I understand it, Ben, decisions of the regulator are going to be published on an acquisitions register where key details will be made public, but not the party submissions themselves. So there'll be much greater transparency, and the reasoning has got to only help businesses and advisors in creating effectively a body of jurisprudence for us all to learn from as it evolves.
That's correct, Mark, yes. And also the ACCC, our competition regulator, generally publishes very useful guidelines, and there's a wealth of information, publicly available information to assist merger parties. But I think that's right, Mark. I think we will see a lot happening in this space, and the market will be more and more informed as time passes.
Well, that's all we've got time for today. So I want to thank both Ben and Jackie for those very useful insights for those from the US who are potentially looking to invest or advise people looking to invest in Australia. Thanks to everybody who has listened today as well. And as always, please get in touch with us if you have any questions. You can find our details on our website, which is hallandwilcox.com.au, or connect with us on LinkedIn. And if you enjoyed today's episode, then please rate, review or subscribe to our podcasts wherever you get your podcasts from. Thanks very much.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.